Welcome back to part 2 of our interview with Attorney Noel Lazaro. Attorney Lazaro, going back to the case involving Philippine Airlines and the FASAP, there are two contradicting, opposing statements from both camps. First is from the prosecution when they said that they wanted to show why the Chief Justice was partial to PAL. And then another statement from the other camp, from the defense, saying that the decision on PAL-FASAP case was made by the whole Supreme Court and not by the Chief Justice himself alone. What is your reaction to this?
Leslie, let me clarify about that FASAP versus Philippine Airlines case. So that's very important. It is only important in the sense that the Chief Justice simply has nothing to do with it. Right? That is important to us. In fact, we were happy that they presented a witness coming from FASAP itself in the person of its president, because he testified that the involvement somehow of the Chief Justice came only from their having speculated on his participation because of an October 4, 2011 resolution in an administrative matter decided by the Supreme Court en banc, not just a division, but the Supreme Court en banc, meaning the Supreme Court sitting as a whole, in that they merely speculated that somehow the Chief Justice participated. I'm not saying even intervened, meddled, or intruded. And they were just saying that somehow the Chief Justice participated because that resolution of the Supreme Court en banc lists some of the justices who did not take part. So this resolution says took no part, and then below it the names of some of the justices were listed. They were saying that the Chief Justice's name is not included there. Therefore, he must have participated. And the doubt in their mind is fueled by the fact that in previous resolutions or decisions, they were saying that always the name of the Chief Justice appeared as not having participated. So that is their premise. Now let's examine their pieces of evidence. The evidence, the very documents that they presented. What are these resolutions and decisions? But first, let me just momentarily veer away from that and show you what exactly the article of impeachment pertaining to the FASAP versus Philippine Airlines is all about. They were alleging that the Chief Justice, and here's the factual allegation, the Chief Justice allowed the Supreme Court, number one, allowed the Supreme Court to act on mere letters of Attorney Estudito Mendoza. Second, the third, that action of the Supreme Court resulted in the flip-flopping of the decision in this case of FASAP versus Philippine Airlines. Now, first rebuttal, number one, the Chief Justice allowed. That itself is not an offense, much less an impeachable offense. Certainly, the Chief Justice can allow the Supreme Court to do about its business. It cannot interfere with the workings, with the thinkings of the other justices. Number two, they're saying the Supreme Court acted on the mere letters of Attorney Mendoza. What are these letters? Everybody knows about these letters, but nobody ever bothered to take a look at what these letters actually contain. You would not believe me that. After looking at the letters, you will be surprised that they are actually all procedural in nature. First letter merely asks about who are the justices in the division and who is the justice tasked to write the decision. This type of inquiry is allowed under the internal rules of the Supreme Court. We do that all the time. Lawyers do that. If you are the litigant, you are a lawyer, you would know where the people are going to pass judgment on your case.
That's right.
That's
very basic.
Very basic. It's readily rebuttable. It's understandable to write a letter of that nature. Second, Atty. Mendoza, knowing fully well that there were retirements already and new justices assumed. So he wrote a letter not to the Chief Justice, not to Chief Justice Corona. All these letters were addressed to the Office of the Clerk of Court. In the second letter, he was saying, since there were retirements, who are going to pass upon the case? Will it be the third division or any other division? Please notify us.
Okay.
He did not receive the response. Third letter, okay, this time he received a resolution from the Supreme Court Second Division. And to his surprise, because all along, all the prior resolution and decisions came from the Third Division. Naturally, a lawyer of Atty. Lito Mendoza's caliber would inquire, why was the case raffled to another division? To his mind, that certainly is not the case. You need to have some re-raffle of some sort to be able to transfer a case from one division to another. So that was just his point of inquiry. And then the last letter that he wrote the clerk of court was just to remind the clerk of court that he received no answer from all these letters. And he requested the clerk of court, please forward my letters to the justices composing the second division. Those are all the contents of the letters. They were saying it's wrong to write a letter to the Supreme Court. But here's the question. Did they not themselves also write a letter or letters to the Supreme Court? They did. FASAP members wrote not just one letter to the Supreme Court, but quite a number of letters to the Supreme Court. And what do these letters contain? They contain arguments on the merits already. That's why one of them, one of the letters was furnished to the other party for comment.
Yes.
The other letters were not sent to the other party for comment, but they were endorsed for consideration of the justices. Now, what happened to these letters? Why the so-called recall of the decisions? Right. From the second division, because of the letters, the second division forwarded the case to the court en banc, asking that the court en banc accept the referral. This is also allowed under the rules.
Yes.
And then the Supreme Court accepted the referral. So from the third division, it went to the second division. From the second division, it went to the court en banc. And the court en banc momentarily recalled that order because it wanted to look into the allegation of the possible mistake in the referral from the third division to the second division. But the thing is, they were saying about the flip-flopping, there was simply no flip-flopping. As things stand right now, there is still a favorable decision for FASAP.
Yes.
So let me just backtrack a bit. When FASAP petitioned the Supreme Court granted their petition. That's the first winning decision that they received. PAL filed a motion for reconsideration, denied.
Okay.
That's the second
Yes.
winning decision in favor of FASAP. PAL filed a second motion for reconsideration, denied.
Okay.
That's the third winning decision in favor of FASAP. Is there a flip-flopping there? Neither is there a flip, nor is there a flop. The decisions are quite consistent in
Yes.
favor of FASAP. There was simply just a momentary recall in the third because the Supreme Court en banc as a whole, not just Chief Justice Corona because he has long inhibited from the case.
Mm-hmm.
So it's a unanimous decision from the court en banc. Not a single dissenting opinion was issued, momentarily recalling the third favorable decision because it wanted to look into the possible oversight in the transfer of the case from the third division to the second division. That is just what is pending right now.
Okay.
All right. So they cannot say any shadow of doubt that the Chief Justice should be impeached on the basis only of a speculation that has no basis in fact and in law because of the FASAP versus PAL issue.
Yes.
So that's why I said a while ago, Article 3 is deader than a doorknob. It has no leg to stand on as things stand right now.
By saying it's deader than a doorknob, are you saying that there's no opening anymore for...
I don't know how they will be able to resuscitate or revive Article 3 right now. They were given their opportunity, a day in court, so to speak.
Yes.
And they were able to present only a single witness. And right now they admitted that they will no longer pursue the other charges. And they will just rely on this FASAP versus PAL case. And FASAP versus PAL case does not only rise to the level of an impeachable offense, it is not an offense in the first place. The Chief Justice has no hand. And the voting, the Chief Justice did not intervene in any way.
Very well said, Attorney Lazaro. I
Leslie.
thank you for this time you've given us.
Yeah, my pleasure.
Till the next interview. By the way, what do you expect to happen tomorrow? Is the Justice Secretary coming back to the...
The Justice will come
witness
back
stand?
for the continuation to cross-examination of Justice Cuevas. I think they will proceed with Article 7.
So you think it will be
but
more interesting?
I don't think that's interesting. As you may have seen, only 6 of the 20 senators were seated at some points of the testimony of Secretary De Lima. I'm sorry to have to tell her that the senator judges did not seem to be very interested in what she had stated. And I don't know if that sends signals as to how they will appreciate or evaluate her testimony, but that there was just simply no excitement to fuel any form of interest for today's hearing.
Okay.
All right.
Thank you very much,
Thank you,
Attorney
Leslie.
Lazaro.
My pleasure.
Thank you for joining us once again with the Defense Chronicles. This is Leslie Bocobo.